You're listening to the Unmitigated Podcast, the podcast that brings to light the hidden risks business owners and entrepreneurs take every day that may not be covered by their traditional insurance. Here's your host, Van Carlson.
Hello, Van Carlson. Welcome to the Unmitigated Podcast. We've got a great guest today, Brad Dixon. Brad, tell us about yourself and what you do for us.
Yeah, for about 25 years, I've been a trial lawyer here in Idaho. I do a variety of commercial litigation work, construction. Been working with Van here for, 10, 12 years,
Yes.
I think. So we've known each other a long
I've
time.
needed your services from time to time.
Yes, I am a partner and co-chair of the litigation group at Gibbons Pursley, which is a pretty significant firm here in Boise.
Yes, it is. Yeah. You've been a great attorney for us. You kept us out of trouble. And I know that's not easy to do sometimes. We can be cowboys in Idaho. So,
Absolutely.
When it comes to business structures and all that kind of stuff that we do, that we've always consulted with business owners, and for a long time. And one of the things we do see several different pitfalls that come out, right? I mean, we're looking at, we saw companies that didn't even have operating agreements, right? And try to unwind a company that's been around for 10 to 15 years and an operating agreement can get very dicey. So that's like the first thing you got to do, right? Is put an operating agreement in place. And I see some people doing some LegalZoom stuff and all that kind of thing. But what's your thoughts on that kind of a deal?
I actually don't mind LegalZoom. I don't mind. I don't mind some forms. I mean, look, you got to start a business. You don't always have tons of money to start a business.
Yeah, it's true.
And there are documents out there that it's reasonable to get off the internet. But I think that has to be for a very short period of time. Eventually, you need counsel. You need to make sure that your business is being taken care of for what the business actually is and what your ownership situation actually is. So to get started, yeah, maybe you get away with a base operating.
And wouldn't you say, depending on how the business starts, meaning if it's a husband and wife starting a company, that's one thing, right? When you start putting partners into the structure, it probably even would it magnify the need to get counsel sooner than later?
Absolutely. Yeah. I think depending on where the funding is coming from. And a lot of times you have a circumstance where you got somebody that's kind of the knowledge of a business and then somebody that's the money for the business. And that's a situation where you really need to understand what your relationship is going to look like going forward, because you've got one person that's going to perceive themselves as kind of running it. And then you've got somebody else that perceives themselves as having funded it. And that's an important distinction.
Yeah, absolutely. I mean, it's one of the dynamic. I have a business partner, as you know, right? And we were just talking about this. We've been business partners for 17 years. And, let's be honest, most of that stuff doesn't last that long, would you say?
That's right.
So,
very rarely does it last that long.
Yeah. And so I think one of the big complications of business when you have partners is understanding the roles, like you said, and all that kind of thing. One of the things that we, I bear witness to, ensuring clients, business owners over the years is when they haven't had things in place and the company's grown significantly over time. And so one of the things that gets brought up is the buy-sell agreements. And can you explain that a little bit, what that does and what that looks like?
Sure. I think of a buy-sell agreement as kind of a business will. It's sort of an estate plan for a business. And it really is designed to deal with what happens if one of your business partners passes away. What happens if one of your business partners retires, bankruptcy, divorce, all sorts of other triggering events. But it really is designed to give you some certainty outside of the traditional trust and estates process of what happens with a business, with an ownership interest in a business when one of these events occurs.
Yeah, they call it the 3Ds. I heard it recently. I heard the 3 5s. I think it's depression, and there was something else they were adding to the 5D, but death, disability, and divorce, right? And that triggers the buy-sell agreement,
right?
And at that point in time, that becomes a legal document. It oversees the operating agreement at that point in time. And have you seen scenarios where they haven't had those things in place, and what the nightmare are? I guess, can you give us an example of where there was one in place and when there wasn't one in place?
Sure. I mean, generally speaking, if you don't have a buy-sell agreement, what you are relying on is, well, I'll give you an example. You have a business, you've got a partner, business is going along just fine. Your partner goes hunting, falls off a cliff, passes away. If you do not have a buy-sell agreement, you just got a new business partner, and your new business partner might be your deceased business partner's 12-year-old son, right?
Yeah.
And that's what you're trying to deal with, and we see it a lot. I would say probably 20-30% of the significant bits of litigation that we run into are circumstances in which we have, for whatever reason, an event that creates a problem in the ownership structure of a business, and we're trying to figure out how do we deal with this problem where we have an ongoing entity that now all of a sudden can't really work properly.
Yeah, the complications of a minor would be
right.
Oh my gosh,
right,
big headaches.
Yeah. But I mean, if you do have a buy-sell agreement in that particular example, what happens is either the company or that other partner has to buy the ownership percentage for the share, and the 12-year-old gets the benefit of that sale, and the business has some certainty in terms of how it's going to be run and how it's going to be operated, but also there's the benefit to the surviving family.
And would you say that in the document, in the buy-sell agreement, there's normally a formula or determining of the value at the time of death, I suppose?
Yes. Yeah. So we've always got, I would say there's three provisions that are usually critical when we're talking about that. There's the valuation of the interest. There's a variety of ways to deal with that valuation. There's usually a funding mechanism of some sort. And then also typically a payment plan. You don't typically have a circumstance in which the entire percentage is immediately paid over. So, you might have a 3 or a 5 year kind of runway on payments.
So do you, when it comes to, let's say, the formula of the valuation at the time of death, is that as good as the document's written? Meaning, if somebody is contentious, like, hey, that's not enough, or hey, I don't want to pay that much. I mean, how does that guide that conversation?
I would say that's the primary litigation issue inside a buy-sell agreement. Sometimes you have a evaluation formula that's not as well written as you might like, and there is room for dispute in terms of how that operates. You might have the surviving owner taking a position on what the books look like, or what the valuation ought to be, and you've got the family of the deceased member having a different point of view, and that's where the dispute really lays.
Sure. Do you you talked about a minor, but I assume it gets even stickier when you have a spouse involved.
Yes.
And the spouse is becoming the new business partner.
Definitely.
I've actually known of a scenario where an electrical company where they had two partners, high school friends, started an electrical company together, and the guy died unexpectedly, didn't do anything, and the wife got remarried in a year, and guess what? The new husband actually showed up as the new partner.
Right.
So that company didn't last, unfortunately, because of that. That's very frictional, very not a good situation. And he couldn't afford to buy him out, so they maintained a partner. Is that seen a lot when there is not a mechanism to buy the partner out? Or
I would say the funding mechanism is probably one of the most significant pitfalls in a buy-sell agreement. So if you've got the valuation is the most likely source of litigation, the funding problem is typically the biggest business problem. So making sure that there is a methodology in cash sitting around someplace for it to actually be paid, that's a big deal.
Yeah, and normally that's done through life insurance.
Yes.
Would you see that? Yeah. And
Yeah.
so that's, I do think a lot of life insurance salespeople know about this thing, and they definitely try to push it. And they bring a great service to their clients. I mean, they're not trying to, obviously they're trying to sell life insurance, but for what it does, it's probably as important, if not more important, to have something like that in place than your own personal life insurance in place over your business's life insurance. Wouldn't you say?
I agree.
Yeah.
Yeah. I would say this too, and this is probably one of my biggest pieces of advice. You get a buy-sell agreement, you got an operating agreement, and there is this tendency to think, okay, we're great. let's go do the business, focus on the operations. You've got to think about your buy-sell agreement like you think about your will. If you've got a 10-year-old and a 12-year-old, you've got one circumstance with a will. If you've got a 20-year-old and a 22-year-old, you got a different circumstance. Same with the buy-sell. When the buy-sell agreement is first entered, you might have an emerging business. You get 10 years down the road, your company may be worth a whole lot more.
Yeah, right.
Yeah.
You got a big enterprise going on.
Yeah.
So what would you recommend on a biannual review, or how do you?
I don't know that it's necessarily annual, but I think if you see significant growth in your business, and you have seen more employees, more profits, you're probably looking at a bigger buyout, and you might be underfunded, right? So if you're relying on an insurance product to make sure that you've got the ability to purchase that share, whether that's the company or whether that's one of the other partners, you got to make sure that there's sufficient funds to actually do it. And if you haven't thought about the structure for a while, you may be surprised about what that funding mechanism actually would do to the company.
Oh, yeah. I'm thinking about all the hair that could potentially be, what happens when you have a partner that's not insurable anymore. Because what happens to your point, you get down the road, you've become successful, you've gotten older, you've probably had some stress along the way, and now you actually put yourself in it. So, I mean, go big as you can in the beginning, I suppose, most you can afford. Yes. And, I would recommend a conversion term. Start with a term and do a conversion over a period of time and all those good things, because eventually you're going to want these things in place for a long time, not just Yeah,
that's right.
People get wrapped up in the deductions of premiums and all that stuff, and that's a very complicated issue. And I don't really, we're also in the tax mitigation area too.
So tax lawyer on for that.
Okay, fair enough. I agree. It gets sold to business owners a lot how to write off premiums. I would just caution business owners about that, because to your point, that benefit comes back into the company. Technically, it can. So it just depends on how you put the buy-sell agreement together. But when it comes to spouses, getting back to spouses, is one of the things I believe, recalling when I went through this with my business partner, the consent forms. Mm-hmm. And can you explain that a little bit, just so business owners understand that is a key component of making sure this buy-sell agreement's legit?
Yeah, absolutely. I mean, functionally, what you are doing is you are asking the spouse, because a lot of us live in community property states, right? That's what we've got here in Idaho. A lot of the Western states are community property states. You're basically asking the spouse of one of your business partners to sign and acknowledge that in the event of a triggering event, death, disability, whatever the triggering events are, they're acknowledging that they do not have that community property interest in the actual ownership interest of the entity. It's belt and suspenders. That's really the situation.
Yeah, and that's I mean, without that consent being signed, I mean, you pretty much would it be considered still a valid buy-sell agreement, or?
Probably, but it's a much better practice to get that consent. Yeah. It really is.
I just know I've been in situations where business owners didn't really want to go talk to their spouses about it. I'm like, that needs to get signed.
It does.
Yeah.
And I think, again, treat it like part of the estate plan, right? I mean, you're going to talk to your spouse about the estate plan. The spouse should understand what's going to happen to a significant business interest in the event of the partner's death.
This podcast is called Unmitigated, and it is one of the things that we see unmitigated a lot for business owners. It's like the will. It's like any of this stuff, right? Well, it's talking about my demise, and when it doesn't thrill me, I want to avoid it at all costs. But I think we've kind of hit on pretty hard about the when you don't have those things in place. The other thing about the 3 Ds I'm always curious about is the third one, divorce, because that is so prominent in our society, obviously. And two, this is, when you're building the business, stress gets added. I mean, it would be interesting to see the divorce levels at some point where it comes to a successful enterprise and you sold your soul to the company basically to grow it, and you neglected some things, right? What is it? Is that really a triggering event to be bought out of your company? Or, I mean, how do you see that being handled?
So what happens in a divorce situation is you're basically saying, you're taking an estate, right? The marital estate, and you're going to divvy it up. I would say most of the time, what happens in the process of a divorce is the spouse is paid for the community interest of a business interest like this. It's sort of settled, right? That's typically the process. But you get into a pretty messy divorce, and you might have a spouse that says, "No, I want my half of that company. I want my half of that interest in that company." And in that scenario, yeah, I think the buy-sell agreement really does need to deal with that problem. And there's a variety of ways to deal with that. You can have mandatory buyout of the spouse's interest. You got to use that. You got to use that.
You would use the same formula
right.
that would be set in place.
Same form, right? And that's why that notice to that spouse is important, right? But yeah, some do have that as an actual triggering event where the company will buy back the interest.
Yeah, and that that can be a really contentious issue in itself.
It is.
So,
and I tell you too, that's one of the, when I tell you that litigating the valuation of the company is a significant litigation problem, bump that up about 30% when you're dealing with a future ex-spouse of your business owner.
Yeah, I would imagine. Yeah. That's why you guys stay busy.
That's right. But the good news is, get yourself a good agreement, then you don't have to hire me to litigate it.
And if you do, then you know that you're confident enough that the documents done, and no documents bulletproof by no means.
Sure.
I mean, I've come to realize that, and I don't know how long these agreements would have to be bulletproof. I couldn't even think of.
Well, yeah, there's no such thing as bulletproof.
No,
obviously.
there is.
But you're better off starting with a base, and some understanding of what the parties intended.
Well, and knowing the spouse knows this too, that in the event of, there's also protection for the surviving spouse.
Sure.
Let's be honest. I mean, there's risk involved. We've dealt with a couple. I can recall right now where, the surviving partner was taking on a heck of a lot more risk now because the other partner was crucial to the operation and he's no longer there.
Absolutely.
It's in the interest of the surviving spouse to get their money out of the company at that point in time. I mean, and so anyway, there's definitely a lot of integral issues when it comes to the buy-sell agreements. What happens when you have like 3 partners? Is there any difference on that, or 4 is there any additional issues to that because there's a third? Or
typically I would say the funding becomes a little bit easier because you're not
splitting it 3 ways.
You're not likely to have to deal with like 50% of the ownership interest, so that becomes a little bit easier. More people, potentially more opportunity for conflict. More opportunity for more personal issues potentially. But I think I would say the most difficult circumstances are when you've got a 50-50 ownership. So, the second you start having 3, 4, 5, 6 different owners, it's a lot of times an easier circumstance, especially in the funding.
Would you, that brings up another issue, is buyouts, right? So when it comes to partnerships, let's say the partner wants to buy out and be bought out.
Mm-hmm.
That needs to be addressed in the operating agreement up front, does it not? That's another key component of the operating agreement.
It does. And I think that's, one of the things that we will often see, especially in the 50-50 ownership structure, is you will have a circumstance in which one of the partners wants to say, okay, I'm done. I'm out. I don't want to do this anymore. If the operating agreement or buy-sell agreement doesn't respond to that question, it can be very difficult and sometimes just end up in a dissolution lawsuit where you've got functionally deadlock in the company because one wants to work and one doesn't want to work. So yeah, I think the operating agreement needs to deal with that concern. I think the buy-sell needs to deal with that concern. A lot of times this is thought about in the context of retirement.
Sure.
Or one of the other triggering events, especially in a little bit larger companies, is when the partner decides they no longer want to work for the company, right? So you've got a lot of businesses where the expectation is that the partners are going to actually be working with the company, actively involved with the company. Mm-hmm. You see this in a lot of medical practices and legal practices. The second they make the decision that they don't want to practice anymore, then the ownership percentage is repurchased by the business. And that in part is designed to deal with this question of I want out.
Right. So would you have, would you have a formula in place for that? Mm-hmm. And then the mechanism is very difficult to fund, obviously, because nobody's passing away, so
Right.
there's not a triggering event for a life insurance payout.
That's right.
Is it more along the lines of, it's a dicey situation because you can't sit there and leverage the company to buy a partner out because what you just do, you put the company more at risk because of leverage. How does that normally work? Is there pay structure, I guess,
Yeah. Typically we would see a longer funding period. You also have the restricted covenant issue, right? You don't want a business partner to leave your business and walk across the street and set up the competing business. Good news is this is a great place to restrict that. And you're talking about the sale of business ownership interests. So we're not running into our friends at the FTC restricting non-competes.
I was going to ask you about that. On that level of a non-compete is what we're talking about essentially.
Yep.
You're being paid for your non-compete, and it's one thing from a non-owner employee leaving and not a non-compete versus an owner. Okay, has that been dissected in that?
It has. The FTC rule, if it does in fact go into place, would impact employees, and it would not impact a non-compete that is the consequence of the sale of business interest.
Yeah, for you folks that don't, non-competes were basically, July 1st it was going to happen, right? Where non-competes were no longer going to be valid, and I'm glad we talked about that because I couldn't understand. That would really hurt a business valuation, right?
It would. Yeah.
If the guy I'm selling to can go out and start another company the very next day, what values? It hurts everybody. It hurts the seller and the buyer in those situations.
Yeah.
No, that's good. So on the flip side of things, we talked about obviously putting an operating agreement, piggybacked on with the buy-sell agreement. Is there, and maybe we hit a little bit on the timelines. I know, do you wait for the success or you put it with the operating agreement from day one, or what's your thoughts on that?
I would say it depends on the business.
Oh, good point.
And I think that, that's really why, I think if you look around on the internet for a buy-sell agreement, you're probably in deep trouble. This is one document where I would say, different businesses require different types of things. It really depends on what kind of business you're trying to operate. I mean, if you've got a brick and mortar manufacturing business and you've got inventory, you need one sort of reality, right?
I could see where you'd have to have specific underwriting phrases. What's real and what's not at that point.
Right.
What's the value of the company? If it's heavy in inventory, that's not necessarily reflective of the value of the company.
Exactly.
But it might look on the balance sheet like it is. Exactly. I got you.
Yeah.
Okay. Yeah. And then two, the stability of the company, I suppose, or the stability of the industry. I think that's got to hire a good attorney to get that done.
I think this is one where one size does not fit all, and it's a good place to put in some resources to legal fees and get yourself a good document that's properly associated with your industry and with your corporate attorney that knows what you're up to.
Yeah, for sure.
Yeah.
So looking at the kids, I've got with the kids situation, I know we actually have kids working in my company or my kids. Those are always added more complications as well. I mean, I think it comes down to the workability between the partners.
It does. And I mean, this gets back from my perspective to exactly what I referred to earlier. You've got to reevaluate these buy-sell agreements, right? When you first started your company, for instance, your son was quite a bit younger. Now he is in a different position in his life and with the company. It's a different thought process about his position in the company than it might have been when he was 15 years old, right? So, reevaluating that process, you have a child that gets interested in the business and moves into a situation in the company. Your business partners may have a different perspective on where your ownership ought to go in the event of one of these triggering events. There may be a reason to want the kids to be involved.
Right.
So that's why we've got to keep thinking about this. But I would also tell you too, maybe you don't necessarily have to wait for a triggering event to start thinking about the future of your business too.
Oh yeah. Exactly. Yeah. I mean, it should be coming in there all the time.
Absolutely.
That brings up another key employee, right? When do you see the need to start to manage that risk when it comes to your key employees, key revenue makers of the company or whatever, right? So that are not non-owners, right? Yeah. This is for non-owners of companies that are revenue drivers for you as an employee, for you as an owner.
Yeah, for years we would talk about key employees from the perspective of, making sure that they're insured, making sure that they have restrictive covenants in the event they decide to leave. I think with the FTC rule and having a circumstance in which we may not be able to restrict key employees from going and competing, I think it probably means that a responsible business owner, especially one in a smaller company, needs to start thinking about ownership percentages and ownership involvement with those key employees probably earlier than they used to. You do not necessarily have the ability to restrict them like you used to. Maybe that's good, maybe that's bad, depends on your point of view and your business. But I think you can use things, other compensation methodologies, and certainly ownership interests to get them in, keep them with the business, keep them involved.
And in order for, I get where you're going now, because if you give them a percentage of ownership, even if it's, B shares of a company or phantom stock, right? Where there's hooks in there that says, hey, we're going to exercise this. I mean, because then you fall underneath the ownership of the non-compete. Right. Okay,
that's exactly right.
Yeah. So and it's just good business anyway. I mean, that just, and people help grow your company. They need to reap the rewards as well.
That's right.
So,
that's right.
And if you're in a position to do it, you should do it. We've done it, and I think it's good for everybody. There's definitely a buy-in to that, right? Sure. I mean, and I know we've got some vested periods and everything else. So I think those are another good planning things that you need to have a legal attorney for to look at and say. And then too, there is no, when do you decide to do that, right? So that's going to have to come down to you personally in decision making, or
may require you to really think about how important some of your employees are.
Yeah, that, and too, truthfully, regulations are changing, and that will drive the bus to some degree, right?
Yeah, and I think the generations are different now too, right? I mean,
good point.
I think we have to realize, I see this in my business a ton, but the younger generations don't think about being with a business for 30 years. It's just not necessarily the thought process.
It's true.
Yep.
Yeah, it's true. Yeah. Well, no, I hope you guys appreciated this information today. Lot to think about. It's not easy running a business. Just trying to take a business and turn it into a profitable enterprise is one thing, but once you turn it into a profitable enterprise, that brings up a whole nother bunch of issues, right? Yeah. So
pay your lawyer a little bit now and not a lot later. That's my best advice.
That is good advice. Anyway, thanks for joining us today. Hope it was informative. Again, thank you guys for your time at the Unmitigated Podcast.